Good afternoon, Mr. Chair, Mr. Deputy Chair, Honourable Senators. Thank you for inviting me to address you today on the subject of Bill S-215. First, I echo the sentiments of the distinguished witnesses who have preceded me this afternoon. The disproportionate victimization of Aboriginal women is a stain on Canadian society in general and on our legal system specifically. It is a complex problem that has its roots in Canada's ongoing legacies of colonialism, institutionalized racism, and systemic discrimination. For both Aboriginal men and women, the results have been nothing short of lethal. It is shameful, and it stands to this day as a blemish on our national character. Seen in that light, Bill S-215 is surely a well-intentioned attempt to recognize the victimization of Aboriginal women and to protect them from this recurring violence. Senator Dick should be applauded for attempting to address what appears to many to be an intractable and confounding problem. But as any criminal lawyer can tell you, good intentions are insufficient to make good law, and Bill S-215 is not, in my respectful view, good law. I say that for 4 general reasons. Before turning to those reasons, I offer the following observation. It is well established as a matter of both statistical analysis and judicial notice that the overrepresentation of Aboriginal people as victims of crime is also inextricably linked to the flip side of the coin, the overrepresentation of Aboriginal people in the justice system generally. That point was made clearly in a recent report by the Department of Justice, which found that, quote, perpetrators of violence against Aboriginal people are most often other members of the Aboriginal community, such as spouses, relatives, or friends of the victim, and as such, victimization among Aboriginal people in Canada is often regarded as a mirror image of Aboriginal offending. These numbers must be put in their historical and cultural context. As the Truth and Reconciliation Commission put it, quote, violence and criminal offending are not inherent in Aboriginal people. They result from very specific experiences that Aboriginal people have endured, including the intergenerational legacy of residential schools. Indeed, many studies highlight that acts of violence are often committed by individuals for whom violence has become normalized, having themselves been victimized, particularly in childhood. For this reason, the Supreme Court of Canada has directed judges to take judicial notice of such matters as the history of colonialism, displacement, and residential schools, and how that history continues to translate into lower educational attainment, lower incomes, higher unemployment, higher rates of substance abuse and suicide, and of course, higher levels of incarceration for Aboriginal peoples. And this disproportionate representation is particularly evident when the violent crime in question is homicide. In 2014, the overall rate of Aboriginal persons accused of homicide in Canada was 10 times higher than the rate for non-Aboriginal accused persons. In that same period, the rate of Aboriginal females accused of homicide was 23 times higher than the rate of non-Aboriginal female accused. With that background, the inherent problems with this proposed legislation become apparent. First, I am concerned that, via its adverse and disproportionate impact on Aboriginal offenders, Bill S-215 may be contrary to the guarantee of equality enshrined in Section 15 of the Charter of Rights and Freedoms. Second, Bill S-215 may effectively run counter to the principles enshrined in Section 718.2 sub E of the Criminal Code and articulated by the Supreme Court of Canada in decisions such as Gladue and Ipili. Third, Bill S-215 is unnecessary, as the vulnerable nature of victims, both by individual and class characteristics, is already well recognized as an aggravating feature on sentencing in both the Criminal Code and the common law. Fourth, given the minimal deterring effect of sentencing consequences on violent offenders, this legislation is likely to have no more than a marginal effect, if any, on the commission of violent offences against Aboriginal women. I conclude with this final thought. Experience has taught us that the criminal law is an unfit instrument for symbolic actions and social policy. The criminal law is a blunt tool, more akin to a sledgehammer than a scalpel. And nowhere is this more evident than in the law of sentencing, which requires judges to craft fit sentences upon a detailed examination of the offense, the individual offender, and the specific social context that brings that offender before the court. Judges are well suited to that task. Parliamentarians are much less so. I'm happy to expand on any of these points in response to your questions. Thank you very much for your kind attention.
Thank you. Mr.